ayes and votes. As it pleases the court, Judge, it appears that the applicant or my learned colleague has stepped out, and I think his attorney is just fetching him at the moment.
Yes.
Case number 18079 and 818204 of 24 on this squad. Fortunate was royal, and 9 others was no contrary, deceased very political party and another.
Court, please, my lady.
Thank you, Mr. Shitando.
I appear on behalf of the applicants.
May it please the court, my lady, I do appear on behalf of the first respondent, together with my senior, Donald Wolf, who unfortunately is not able to attend today's hearing, and I will be standing in for the matter. I am also briefed by Zingo Incorporated attorneys.
Zingo Incorporated. I just been looking to see whether your heads of argument are here. Good, thank you. Mr. Shitando?
As the floor pleases, my ladyship, I believe we've got two sets of heads of argument.
Yes, that's correct.
The applicants will just deal with what I believe are the most important points within my heads of argument, and then stress the essentials regarding the terms that we need to satisfy, the requirements of the interdict. And my heads do mention that if successful, the applicants would like to file a replying affidavit if an interim order is granted today, and my ladyship is satisfied.
So you have to speak up, Mr. Shitando.
I said, my lady, if the court is satisfied and we do reach the threshold for an interim interdict this morning or today, the applicants would then be in a position to file a replying affidavit ahead of a...
But is the matter ripe for hearing if the replying affidavit hasn't been filed?
At this point, I believe it is. We can move, the applicants want to move on the basis of the papers that are before this court.
All right.
My lady, the respondents have, the first respondent disputes jurisdiction. Again, the second respondent, the Speaker of Parliament, has filed a notice to abide, and they have got no argument against the relief before your ladyship. The jurisdiction, the respondents are claiming that, look, the decisions that are before this court in the review application were made in Nkandla and not within the area of this court's jurisdiction. And the submissions that the applicant would like to make in that regard is that the MK party, like all other parties within the National Assembly, have a presence, have offices within this court's jurisdiction in the National Assembly. And those offices are within this court's jurisdiction, and on that basis, in terms of Section 2.1 of the Superior Courts Act, this court does have jurisdiction to hear this matter. In regards to locus standi, one of the issues that the most important issue, I'd say.
Has urgency been agreed? Has it been agreed that the matter must be heard as an urgent application?
When the matter was brought before Judge Erasmus, Judge Erasmus did set this matter, or postpone it to today. And he did so on the basis that, he understood that it was urgent, even though he didn't expressly, I think he might have mentioned it in the hearing. but he did not. He said that that's something that you have to deal with then. But the urgency, my lady, has not been agreed, and the respondents are arguing that the matter is not urgent for the reasons set out in their heads. But I'll get to that. What I'd like to do is just deal with jurisdiction first, then, which I think I already have, and it's been dealt with in more detail than I've mentioned on my feet, in my head. Then locus standi, urgency, and I'll go through the merits of the incident. In regards to locus standi, I couldn't understand the respondents' dispute or their argument for locus standi. Obviously the applicants are acting in their own interest. They're seeking relief for themselves and for their dependents. But I think what I'll do is just deal with what former President Zuma's submissions were in his answering papers. He says at paragraph 22, absent any allegation of membership of the MK, the applicants have no standing to seek the relief directed at the MK. It must therefore be released from this application. My lady, the founding affidavit in the review application in paragraph 9 makes it very clear. In fact, they do say, all of the applicants, they said that...
But don't you need to use Plascon Evans to resolve disputes of fact in motion proceedings? This is why there's no reply. We must determine the matter on the basis of the rules set out in Plascon Evans.
Yes, my lady, but just
so
based
what do I do with a factual dispute like that?
Well, the founding affidavit says that there are.
So what I'm saying is on Plascon Evans, how are you asking the court to deal with the issue? You've got the founding affidavit that says we are members, and you've got the answering affidavit which says that you're not.
But what we do have is the answering affidavit saying two different things. The answering affidavit, former President Zuma's answering affidavit, says two different things. He says that they were never members of the MK party. And then he also says, I'm going to get to that, he also says that he used his powers to remove them. You cannot remove people that are not members of your party to begin with. So his own answering affidavit, in that respect, it makes out the case that the applicants require in regards to the locus standi. I'll get to that in more detail, but he does say, in fact, I mean, in the paragraph in my head that where I discuss the discretion of this honourable court, I do mention that, and I like to, I've got no other way but to use strong language, the deception of that answering affidavit. He says, they were never members of my party, and the same papers, I got rid of them. And on that basis, my lady, I think it's pretty clear that the answering affidavit does set out that the applicants were indeed members of the MK party without a replying affidavit to dispute that. And the Plascon Evans rule does say that the answering papers, if they're far-fetched, and obviously this matter, on that point particularly, they are far-fetched. He's cancelling his own argument out. My lady, that is the case for at least the locus standi. Section 38, obviously, of the Constitution does provide anyone acting in their own interest, as these applicants are, to approach this court for relief. In regards to urgency, my lady, there is no agreement for urgency. The challenge, I assume, and just by looking at the respondents' heads of argument I received this morning, is the time that is preceded for us to be here, or at least preceded for the first hearing before Judge Erasmus. We have a letter from Mr. Jenkins, the senior parliamentary advisor, where he says the position of the National Assembly, the position of the Speaker. That letter makes it very clear that this matter is urgent. just for the sake of not just the record, it's already in the heads, but to assist me making the argument, I'd like to read out.
What page of the record is this?
My heads of argument, it's page 6, but in the record it's page 6 of my heads of argument.
The letter of the 19th of August.
19th of August letter from Mr. Jenkins. And I believe that letter is page 5 of the founding affidavit. It reads, your correspondence dated 19 August 2024, which we acknowledge receipt, bears reference.
But where's the correspondence?
The correspondence is attached TF2 of the founding affidavit.
Is at which? So what page of the record?
Page 15.
15.
Yes.
Okay. 15 of the record.
15 of the record, and...
But that's... Oh, I see, yeah.
Yeah, there's 15 of the record.
Thank you.
Your correspondence dated 19 August, of which we acknowledge receipt bears reference. The administering of the oath or solemn affirmation by the Speaker of the National Assembly is a constitutional obligation required by Section 48, read with Item 4.2 of Schedule 2 of the Constitution. Section 237 of the Constitution provides that all constitutional obligations must be performed diligently and without delay. Given that your clients are challenging their expulsion from the political party, they should interdict the party from fulfilling the positions, and interdict the Speaker from administering the oath or solemn affirmation of candidates that would be nominated by the party to fill the positions. Without an interdict, there is no legal impediment of the nomination of the new members, and the Speaker must proceed with the administration of oath or solemn affirmation so as to give effect to her constitutional obligations. We would like to add that the Speaker will not be administrating the oath or solemn affirmation of candidates tomorrow at 20 August 2024.
Have the positions been filled, Mr. Chitando?
No, the positions have not been filled. My lady, what I understand, and the papers that have been presented were filed before some, I believe there were some appointments made last week. This is not in evidence, but the positions have not been filled. There are 18 expulsions and 8 positions have been filled, which mean that the 10, the respondents like to call them the group of 10. I will use that in argument as well, as it makes it easier to explain. That group of 10, those positions have not yet been filled. So from the Speaker's correspondence, it is clear that she's informed the applicants that there's a pressing requirement for them to apply for to get an interdict if they would like to assert their rights. That's what we had, and this was communication ahead of the urgent application that was filed, and there was a postponement to delay in Judge Erasmus's, before Judge Erasmus. So the position of the applicants is that we've got this pressing situation. The respondents, they argue that, well, you've taken your time to come, and for that reason you've created your own urgency. And in response to that, my lady, the applicants are going to rely on the judgment by Plaskett J in Nelson Mandela Metropolitan versus, I can't pronounce that, I'll just call it Nelson Metropolitan Municipality case, where it was found that an applicant who seeks from the respondent before lodging an urgent application, seeks compliance from the respondent before an urgent application, cannot be said that they were dilatory in bringing the application or that urgency was self-created. The applicants, and it's made out in the sequence of events coming before this court, they did send communication to the MK party. They did send communication to the Speaker. That communication was not responded to, and they came to court. The dates in the correspondence that Mr. Jenkins and the Speaker mentions, in the last line of Annexure TF2, that we would like to add that the Speaker will not be administrating the oath of the candidates on 20 August 2024. That date was, there was a rumor that was circulating, and in the correspondence they did say, look, we hear that you're going to swear in our replacements on that date. We are going to go to court urgently to stop that. And that is important, my lady, because it shows that the applicants are not sitting on their hands. They're moving quickly. After they got the rumor that there was something was going to take place on the 20th, and obviously their communications to the Speaker and to the MK party went unanswered. That is the most. That is obviously that letter is a compelling argument for approaching the court on an urgent basis, considering that before that also a review application was filed, which is subject of this urgent. The respondents call it Part A and Part B, but there's actually two separate applications. So that review application was filed before coming to urgent court, and without an interim interdict this morning. There's nothing to stop the respondents from simply filling the positions before the applicants have had an opportunity to have their review application considered by this court. My lady, I'm now going to move very quickly. I know we have pressed for time. On the requirements, the threshold for an interim interdict that the applicants must canvass and must persuade this court on. The first requirement being that of a prima facie right. Considering that we've got three prayers that the applicant would like to make orders of court. The first two, I would like to call them the review prayers. The review prayers. And I would have to satisfy this court that the applicants have a prima facie right on those two prayers. Just for the sake of reminder, the review prayers are prohibiting the second respondent from administering the oath or solemn declaration of any candidate put forward by the first respondent to replace the applicant's membership of the National Assembly pending the outcome of the review application before this court under case number 18079 of 2024. Two, prohibiting the respondents from denying the applicants any and all benefits of membership, including the parliamentary accommodation pending the outcome of that review application. And, my lady, go into the prima facie right to these two prayers. The most important fact, I just mentioned it when we're dealing with when my lady was asking me about the replying affidavit and the dispute in regards to local standing. My lady, the applicants in their review application, they claim that, and I quote, they are members of the MK party sworn in as members of the National Assembly on 22 June 2024. We joined the party and the National Assembly after assurances were made that the party was democratic and would be governed in a manner consistent with the Constitution of South Africa and the rule of law. That is what they say in the review application. And obviously it's the rights, their prima facie right is based on the strength of that review application that's before this court. My lady, I go into the heads of argument goes into the letter that they received from the National Speaker, which is self-explanatory. I won't quote it, but it's basically the letter informing them that they were terminated.
Where do you plead in your founding affidavit that you're members, that the 10 applicants are members of MK?
The founding affidavit in the interdict application?
Yes, in the application that's before this court today. And where do you say that these are members of MK and they have a right?
What the founding affidavit does, my lady, in the interdict application, is that it says, and I quote, page 10 of the bundle, paragraph 17. The applicants have filed a review application which provides a background to the merits in this matter. To avoid repetition and unnecessary burdening of the papers, we shall rely upon the papers in the review application under case number 18079-2024. A copy of the application is attached, marked TF3. That is the pleading that is made in the interdict application.
I'm just struggling to find any averment in the founding affidavit which states that the 10 are members of the party.
Well, my lady,
and therefore entitled to any kind of interdictory relief vis-a-vis the party.
My lady, there's a chain. That's the answer, the position of the applicants. We have an interdict application that is saying that this interdict is, and it pleads it out in paragraph 17 of the founding affidavit. This interdict is changed to the review application. The review application says, and it makes the pleading, that the applicants are members of the MK party. And the reason why we have not repeated is because we end up burning the papers.
Because what, sir?
It ends up burning the papers.
Well, it's extremely important that this is a self-standing application.
Yes.
This is not a Part A and Part B relief situation.
It's not.
You've chosen to go the route of two separate applications.
That's
one
correct.
A review application and one an urgent application to interdict the MK party on the terms that you seek in the notice of motion.
And, my lady, that the interdict founding affidavit does say that the case for all the merits are in that annexure, which is an entire separate application. So the interdict application has attached the founding, my lady, to put it differently, the review application in its entirety is part of the interdict application. It's there. It's part of the papers. It's before this court. It's before your ladyship.
Mm-hmm.
It's not just before another judge. It's before you. It is evidence before this court. It forms part of case number 18204, which is the interdict application. The two are not divorced. They are inextricably linked, and they're linked by that allegation at paragraph 17, which says, to avoid repetition and the unnecessary burning of the papers, we shall reply on the papers filed in the review application under 18079. A copy of that application is attached marked TF3. So TF3 is part of the papers before you. It is not standing separately. It's before you. My lady, I'm now going back to the merits for, or at least the prima facie case for the review. The Speaker communicates on the 7th I won't repeat what's said, but just it's important to state that she says she's received correspondence from the MK party saying that you're expelled from that party and therefore you're expelled from this National Assembly. That is, if you want to call it, the cause of complaint. That is why we're here, is that correspondence. Now, how did we get to that correspondence? That's the case for the prima facie relief that the applicants seek. And for that, I'm going to go into what the first respondent has said in their answering affidavit. I did say I'll concentrate on what's really important. What the first respondent says in their answering affidavit, which is the evidence, which was deposed by former President Zuma. For the sake of this argument, I'll refer to the former President Zuma, with no disrespect to the former president. It just makes it easier to argue. Zuma says that the MK party is a new party. He says it, and I want to quote, he says that it is his brainchild. That's what he says. And he says that his brainchild, MK party, has been governed by 3 phases. 3 phases governed his party. His words, the first respondent's words. The first phase ran from June to December 2023. The second phase ran from January to August 2024. And the current phase, the third phase, August onwards. But he doesn't give a specified date. He just says there shall be a Congress in the future. Those are the 3 phases. The second phase, and I suppose just following at this point, my lady, I'm at page 11 of my head. The second phase was governed by what Zuma calls the Interim Leadership Corps, the ILC. Now, that is the most important phase, because it's the phase where the decisions that are subject to review were taken. It was during this ILC phase, if I call it, or second phase. And this phase, according to Zuma, and I quote, and I will refer to the exact paragraph shortly. The ILC, in its second phase, the phase in question, gave Zuma the powers to deploy all members of the MK party and sole discretion, at his sole discretion, until the democratically elected structures would be put in place. Implicitly, what he's saying, by saying, look, there will be a democratic phase later on, suggests that there is no democratic phase right now, on the respondent's own version. That's what he says. So he's got all the authority in the MK party from this ILC. How the ILC was created, the members of the ILC are not mentioned in the answering papers, but according to him, he has sole discretion. And that is paragraph 7.6 of the first respondent's affidavit. And just by the admissions that Zuma has made to have all this discretion and the way it's pleaded in the answering papers, there is no consideration of the just administration or the rights that the applicants have to just administrative action. None. He's saying that I am in charge. This is my brainchild. He can do what he pleases. Sole discretion is the words he used. The applicant's case is that, hold on, the MK party receives taxpayer money. We know that. We know that because they're in the National Assembly. I believe they're also in provincial, the provincial legislature, but in this case, the National Assembly. They also reside, the members of the MK who are in the National Assembly reside in state property. They are a political party, the third biggest party in this country. And the case that the applicants are saying is that you cannot behave in this manner. You cannot say that you can do whatever you like without consequence and without following the law, without following what the Constitution says about just administrative action. And Zuma's excuse is in page 12 of my heads of argument, and I'll quote him. There were serious political and security reasons for the decision, the finer details of which need not detain the court. Suffice to say that the space we operate is highly competitive, susceptible to infiltration and even politically motivated violence, which must be avoided and prevented at all costs. So that is paragraph 7.7 of the answering affidavit. My lady, those are the words of a dictator who says that there may be problems in governing this party democratically. And those problems are politically motivated violence, infiltration, and a highly competitive space. Those are the reasons why he says that he must not govern his party in a manner that is consistent with the right to just administrative action. That is his excuse. He then goes on to, in making his excuse for giving himself, or the IRC giving him the powers that he's mentioned he has, he says, and he accepts them, he admits the chaos in the MK party, he admits it. He says, given the historical messy process described above of clearing up the lists had not really been completed by the time that members of the National Assembly in particular had been sworn in. So he admits, he says that there was a mess before all of the members of the MK party were in Parliament. There was a mess for everyone, not just for the applicants. I obviously had no personal knowledge of all the 800 plus individuals on the lists, nor was it possible to verify their membership of the MK party since the membership system was not yet in full force, which is not completely up to scratch, although progress has been made. So he's making progress in finding out who the members of his party are. And he's saying that he does not know, and we'll go into that later, my leadership mentioned it, he does not know who the members of his own party are. And on that basis, my leader, just on that admission alone, it boggles the mind how the MK party is in any position to be appointing and removing anyone from National Assembly, where they admit not knowing who their own party members are, which is why a review application is important, and it is why an urgent interdict to stop this chaos from continuing to flow, the revolving door of National Assembly, where taxpayer money that goes to members of Parliament is exchanged in manners that do not follow any administrative process internally. And my ladies, also there is an allegation in the founding affidavit which is not challenged by the answering affidavit, where the correspondence to the Speaker does speak to internal processes being made. The MK party said internal processes were followed, and that's part of the review application. The answering affidavit says that I don't need to follow any internal processes because I am in the second phase of my brainchild, this is Zuma, and he's saying that I don't need to follow any internal processes because the IRC is giving me sole discretion over this party, and that's it. And I did...
But Mr. Chitando, are you able to counter the argument that's put up in the answering affidavit that there was chaos reigning in which it was not clear who was a member of the party? It was not possible to verify membership, and that as a consequence of that there was a process that was undertaken, and that the expulsions then followed, which included the 10 applicants, and that none of the applicants has put up any evidence to prove that they were a member of the party. That's the case. That's what's stated in the answering papers.
Sorry, Maddie, did I interrupt? I was going to answer.
No.
The answer to that question, my lady, and I'll get to that in. I'm trying to land the plane as it were, but quickly, the answer is that that Mr. Zuma's own affidavit, he says, he admits, and this is the most crucial admission that's so important to the applicant's case, is that he says that I expelled them. I expelled them. And the reasons, and I was going to go into how he's uncomplimentary to the applicants, but the reasons he sets out. He says that I expelled them. And the argument that the applicants are making is that you cannot say that we're never members of your party if you expelled us. You cannot come back and say, well, they don't have any evidence that they were ever members of my party. When he has said, look, I expelled you. You cannot be expelled from any party or any organization that you were never a member of to begin with. And that is obviously, when it comes to the evidentiary burdens that the applicants will have, that's something that's going to come up in the review application. What do we do?
But there's, of course, a counter-argument that an expulsion is of no force and effect if, in fact, one was never a member of the political party.
But, my lady, in this case, it's not the situation. In this case, it's not a hypothetical situation. This is a factual situation.
This takes me back to my earlier question. There's a factual dispute about, it seems, at some level, membership. And there's nothing really put up apart from a statement in the review papers that the applicants are members of the party. In the urgent application, it's simply not averred.
My lady, I'm going to get into what the test for the prima facie right and all of that later on. But what I'm coming back to, and the point I'm trying to persuade and move your ladyship on, is that the answering papers does not speak to, in regards to membership, a hypothetical situation. It speaks to a situation where there is an admission. My ladyship referred to Pascal Evans, the version of the respondent. There is an admission by Mr. Zuma, who says, I've expelled you. You were in, he speaks to, I'm going to get into the quotes just now, that he says that they don't have the skill set. He speaks to, to members of this party, not people, not arbitrary people or members of the South African public, not citizens that voted from the MK or citizens that who believe in the message that he sells.
One's taking you to Pascal Evans not because that's the determiner for this application.
That's
it's
correct.
Just that I'm dealing with that just simply to raise in motion proceedings these would be the problems. And here you've got to show that there's a prima facie right.
Yes.
And all the other requirements were interdictory really. And it was in that context that I raised it with you.
Yes,
it's just not clear where the prima facie right arises.
I'm getting to where it rises, my lady. But what we do know is that on that specific point, Mr. Zuma says that these are members of my party who are expelled, and he gives reasons. Mm-hmm. And I want to get into those reasons now. We cannot, and I can't put myself in your position, my lady. But what I would say is that it would be difficult for court to say, agree and say, well, look, they're not members of this party when the man who runs the party, who says it's his brainchild, who says that he's got the powers, all powers above all others in the party, he says that I expelled them, and I want to give the reasons now. My lady, going to those reasons. Mr. Zuma is uncomplimentary about his own party, who obviously, these members, the group of 10, this is how he describes them and other members. I'll quote him directly. In any event, some of the members or some of the persons do not even possess the skill set, which is probably a reflection on our regrettable lack of time for screening prior to the submission of the lists. In any event, it fell on me to rectify those teething problems across the 7 legislatures in the country where the MKP has representation and nationally. So, my lady, just that admission alone, just if we were to unpack it, it doesn't take too long to unpack what is said just in that one sentence or paragraph. He says that they had a regrettable lack of time for screening prior to submission of the lists. What they're referring to the lists that the MK party put to National Assembly. That is the prima facie right. That's the smoking gun right there, amongst many.
Sorry, what is the prima facie right?
That is the prima facie right.
Is what?
Just what I'll repeat it, my lady. I apologize.
Is being on the list.
They say that there are members, they were on the lists. They had no prior time. They said, and I'll quote him, I don't want to put words in the former president's mouth, regrettable lack of time for screening prior to the submission of the lists. The lists he's referring to are the lists that the MK party put before National Assembly to say, these are our people, and those people include the group of 10. And then he says what he did to them. And I'm going to go into more detail as we go through the version of the respondents. In any event, it fell on me to rectify, which is why we're here, is rectification. These teething problems across the 7 legislatures in the country where the MK has representation in national. Now I want to get into the decision. The decision that former president made in rectifying what he says is a problem within his party. In the exercise of my powers, and for various reasons detailed below, I determined that the applicants and others must lose their memberships of the MK party and in the National Assembly. That's Mr. Zuma's words. They're not the version, it's not the version of the applicants, it's the version of the first respondent. That admission is clear. You cannot, it corroborates what the applicants say in paragraph 9 of the review application, that we are members of the MK party. Plascon Evans, this is what not that it's necessary here, but I'm going to, I'm going to get to Plascon Evans later when I talk about the test for prima facie relief. But the respondents corroborate. They say that he determined that they must lose their memberships. Not to lose memberships that they didn't have, memberships that they had. And that they should leave the National Assembly. So my lady would have picked up perhaps when my ladyship was going through the answering papers that there's an allegation made that the applicants who are not in the National Assembly properly. But what we do have here is the smoking gun, the admission that they were in the National Assembly by Zuma himself. He admits it, and he explains that they should be removed. That is the decision that is subject of the review application, which is married to this interdict. My lady, and this excuse, again, similar to what he said earlier in his answering affidavit, for these autocratic powers. I did mention dictatorship of his own party, because the IRC were not mentioned or specified in the answering papers, have given him all power to do as he likes. Zuma contends that the applicants have notably never challenged the lawfulness or constitutionality of the relevant protocols. In fact, no member of the MK has ever questioned or challenged the current interim dispensation. My lady, that is the excuse for these things. So he's saying that he's got a crisis and he's got all this sort of discretion to do whatever he pleases.
Now the respondent says, well, the review application is not good because it seems to be that you're arguing it as under PAJA, which doesn't apply, and that it's not clear on what basis you would have any right to, what the grounds on which the review are being sought in terms of what legal framework. That's their argument. That it's not a PAJA review, it can't be, and therefore it's not a legality review. What kind of review? It's not a common law review that this court would engage in, so what kind of review is it? And on that basis, they say there's no prima facie right to relief in an urgent application such as this, to obtain the interdict that you're seeking.
My lady, I'll get to the test for the prima facie right, but I would like to answer my ladyship's question. The review has been sought under Rule 53. That we know.
But that's a procedural.
It's a
procedural approach.
It's
to
a
any
procedural
review.
approach.
It doesn't matter on what basis the review is brought.
Yeah, but it's important that I mention the process, and I'll explain why. The respondents have to file they have a case in front of them, and they have to defend this review. They have to defend it. If a case has been brought against them, they have to defend this review. Because it's a Rule 53, they have to provide a record. They have to, or first they have to file a notice to oppose, which they still, to date, have not done. I was told by Judge Erasmus that the two files were going to be before my ladyship. I'm not sure if that is the case. Okay. There is no notice to oppose.
But I'm asking you a different question. I'm not asking you for the procedural issues.
I'm going to get to the merits of that review. In the limited way in which, in an interdict, an application for interim relief, that I can. The review in that matter, my lady, the applicants are saying that they would like to, they're challenging the just administrative action that was taken, the action that was made, the decisions that were made. The procedure.
But why does PAJA apply?
Sorry, my lady?
Why does the Promotion of Administrative Justice Act apply to a decision of a political party such as in these circumstances?
My lady, the decision of the political party. Okay. But I'll just quickly get to that. I'll go through the definition of the administrative action that is subject to that review application. Section 1 of PAJA defines administrative action to mean any decision made by an organized state or natural or juristic person other than an organized state when exercising public power, performing a public function which adversely affects a person.
So where's this a public power when it's a political party issue?
Well, this is the section. Well, my lady, what we have is a political party that is in the National Assembly, is receiving taxpayer money. Its members are using state property. In fact, the taxpayer money and the state property is material to this interdict. My lady would have noted that I'm dealing with the prima facie right of the review. I haven't the review relief. I haven't yet gone into the relief that the applicants seek in regards to the pay that they were denied and the accommodation that they're currently in. So the state property that the MK party has control over is subject of that review. And this party, and this is what I say in paragraph 53 of my heads at page 14, the MK is the third biggest political party in the National Assembly. It receives taxpayer money and uses state property in the exercise of an essential public function, being a major opposition party.
I mean, the Constitutional Court in Ramakatsa set out how political party disputes should be resolved. And
yes.
It says there that these activities are internal matters of a political party. Therefore, it's the parties to determine how members would participate in our internal activities. Constitutions are the instruments which facilitate and regulate that participation.
Yes, my lady, and in this case, what the applicants are going to do in the review application, I'm not going to, the time that I can use in making a prima facie case, I can't go into too much depth into the review application. At the same time, I can't give an empty argument either for the prima facie relief. But what I can do is say that the applicants, now go to the test that the applicants have to use. I suppose I'll do that now, my lady, so my lady follows where I'm trying to get here. which is the test in the Beecham case. And I think what I'll do is just set up what that test is and show you, my lady, what I'm trying to make out as a prima facie relief here. The test is, in an application for temporary interdict, applicants' rights need not be shown by balance of probabilities. It is sufficient if such rights is prima facie established. Though open to some doubt, the proper manner or approach of the approach is to take the facts set out by the applicant together with the facts set out by the respondents, which the applicant cannot dispute, and consider whether, having regard to the inherent probabilities, the applicant could, on those facts, obtain final relief at trial. The facts set up in contradiction by the respondent should be then considered, and if serious doubt is thrown upon the case of the applicant, he cannot succeed. So the respondents have to show that serious doubt on the review that is on in a different case number. And
well, that's why I raised that issue with you. That's
yes.
what they're saying.
Yes.
That it's not a PAJA review, that it's not a legality review. What review is it? It's not a common law review.
Well, my lady,
that's
it
what
is.
they're saying.
Well, the argument is that it is a review on those grounds. And it's a screaming. It cries out. We have a situation where my ladyship mentioned the courts not wanting to interfere in the internal runnings of a political party. What we have here is admissions made by Mr. Zuma himself that he's not following natural justice, common law, administrative action, the legalities of what one would expect, what the law says about just administrative action. He's not following that. He's told us that. He's not following any of or he's not considering any of the legal principles of the rights that affect the people of the members of his own party. And he's handling taxpayer money. And he is handling, well, his party rather, not him, but he's got sole discretion over it, is handling the accommodation state property. So that is the case that the applicants will then be making. That is the review. Which is the reason why this matter has garnered so much public attention. It's an unprecedented matter where a new party has come into place a short period of time. They're not following any rules, and they've said so. This is a completely different set of facts than the judgment my ladyship referred to earlier.
Can I just take you to the relief that you're seeking? You're seeking a prohibition on the party from putting forward the names of other candidates to the Speaker of the National Assembly, pending the outcome of the review application. You're also seeking a prohibition on the party from administering that oath, although the party, on the Speaker from administering the oath, pending the outcome of the review. And you're then also seeking an order prohibiting the respondents, that is the Speaker and the MK party, from denying the applicants any and all benefits of the National Assembly, from their membership of the National Assembly, including parliamentary accommodation, pending the outcome. So at this stage, have they been sworn in as members?
They have been sworn in.
So
the papers say that.
They've been sworn in as members, and the Speaker has said on page 15 of that letter, through the letter of Mr. Jenkins, that the oath is going to be administered. They've received correspondence, but the oath is going to be administered in respect of other candidates, and that's really what stirred the applicants to bring the application.
So they're going to be replaced.
That they're going to be replaced. They're currently in parliamentary accommodation.
They're currently there. They're sitting there. That's the third prayer, which I was going to get
and
to.
They are still, yes. So they're still in that accommodation.
Without funds.
but they have been removed as members of the party, and therefore the Parliament has taken what steps against the applicants?
The Parliament, before the urgent application was filed, I think it was even the day that it was filed, tried to get them out by force. And my instructing attorney got an arrangement that give us a month. Also, while this matter is taking place, the Parliament, and I think they've filed a notice of IDA, sitting and waiting. They're saying, we're not saying anything. They're not saying that we took instructions from the MK party to pay you less, or we got instructions from the MK party to kick you out. They're saying we're going to abide. And they've also said, if you want to stop all of this from taking place, get an interdict, which is why we're here. My lady, my ladyship has pressed me pretty hard on the sort of the Thank you, my lady. My lady, I've just received an instruction. May
yes,
I?
you may turn your back. Certainly.
Thank you. But lady, there's never a dull day in South African politics. I've just received an instruction. My learned friend will speak for herself, that the parties...
The matter settled?
That they might have settled it.
Oh.
Melody, might I ask for a short tea break? It appears that there are some instructions that we have received on our side, and that is what we would like to discuss with the applicants.
Certainly. Let's take, it's now 12:20. Should we take 20 minutes?
As it is.
As court, please.
Court adjourns.
Court, please. Killing me by the... Sorry?
Dijongile undibonile ndihambela phezulu ndibanda
phethe ubumnyama buphethe mntanazana.
Apparently starts at 2. But I think that I want to have some. They want a quick meeting. Can we do a quick meeting? Okay, let me just ask for a few minutes. When must we be? Sorry, just quick after. Okay. Still in here, but
Mr. Tulu nodding, I see that your own attorney nodding. There seems to be a willingness to try and find a resolution. Let's use the time available to try and seek out a solution. Good.
As quickly
We'll
as
stand the matter down to 2 o'clock and then we can be. Good.
We're very sorry for this confirmation of private correspondence to you and to your dad. The station will be coming in there. You have sent to the
What? You know what it is not. It's to say that we're trying to find an agreement. To say that we are. To say that we are. So the private instruction is exactly what we just said in court, right?
Thank you, Ms. Nyati.
Lady, the parties were unable to come to an agreement during the adjournment, unfortunately. So we'll just have to proceed. In the court's hands in regards to time.
How much longer do you intend to be?
I think I could be probably another hour.
Another hour?
Yes. Well, it depends obviously on how my ladyship, whatever questions my ladyship has from me. I mean, what I could do to speed it up is quickly just, try to hammer through as many of those requirements for the interdict as I can.
But you've set everything out in your heads of argument, have you not?
The heads of, I'm not going to.
So I'm not sure that, I don't want to curtail you.
Yeah, I don't want to curtail the court either, considering these delays and trying to reach each other in agreement.
You've dealt with the prima facie right, you've dealt with the infringement of that right. You haven't dealt with whether there's an adequate alternative remedy and the balance of convenience. You may want to take us to those areas. Are there other issues you want to deal with under the first two heads?
No, I don't think so. But I just want to see where I left off in my head. I think my ladyship is correct on those, what I've dealt with. Alternative remedy and balance of convenience, I think, for the infringement of the right, I think that's speaks for itself. Yeah. So I'll be quick in that case. I won't be now.
Good, thank you.
My lady, what I probably would say is probably, given with the end of my address, probably put another 20 minutes.
All right, okay. You may proceed. Thank you.
The court pleases. In respect of an adequate alternative remedy, my lady, it's obvious from the facts, the objective facts that came from the second respondent, that in the absence of an interdict, the 10 positions that are contested will be filled by alternative candidates. So there is absolutely, without an interdict, and the speaker said so, she will fill those positions without an interdict. And if that were to happen, obviously, my lady, the review application becomes pointless. There's the applicants will be forced out of the parliamentary accommodation that they are currently staying in, almost probably overnight. I'm not sure exactly how that would work, because unfortunately the MK party does not have a constitution. It does not have procedures to deal with the applicants. We don't know what formal process can accommodate not just them, but their dependents. My lady, I understand from our instructing attorneys that confirmatory affidavits were filed this morning, which set out the number of people behind the applicants that will be left destitute. And they don't have an alternative remedy besides an interdict. So it's not just a group of 10 as the respondents call them. It's a group of 10 and their family members. All will be left out in the cold without this interdict that we seek. Can't really take it further from that. When it comes to, I think, one of the strongest, I won't say strongest points, I don't want to speak for the respondents, but one of the points that is emphasized in detail in the respondents' heads of argument is the balance of convenience. They say that Parliament would be left hamstrung by an order that that sets the status quo as it is pending the review application, it's still to be decided. My Ladyship, my argument would be that the applicants, the group of 10, have made it clear. They will continue. They're already in parliamentary accommodation. They are prepared to go to, some of them are in parliamentary committees. They are prepared to go to the National Assembly and fulfill their duties. And fulfill their duties as members of the National Assembly. The first respondent will not be prejudiced at all. The ability to function as, I think they're now they're outside the government of national unity. They are the leading opposition party. That's what I've heard. I think it's common cause. It's down in the papers. What might be. But the most important thing is the MK party will not stop its functions. They haven't been prevented from continuing their functions, and while all of this is taking place, this litigation is taking place, they'll be able to continue to do whatever would be the opposition, and the respondents will not be prejudiced, and the applicants are prepared to continue on their parliamentary committees and whatever is required from them by the National Assembly. So there's no prejudice to them. The second respondent, the Speaker, has said that she will abide by the decision. So there's no prejudice to the Speaker. But, my lady, I do believe, given the submissions by Mr. Zuma, apart from the group of 10, apart from the dependents, democracy in this country, the constitutional democracy and the rule of law, that would be inconvenienced, I believe. That's a submission from where I'm standing, if the court doesn't grant an order. And my head's going to that. My lady, in regards to the discretion that my ladyship has, I have to persuade my lady to exercise your discretion in favor of the applicants. That's why I'm here. And obviously the Respondents' Council is going to argue that you should exercise your discretion in favor of the MK party. In exercising your discretion, my lady, I put this in my head, but I think it's important to emphasize this on my feet. If my ladyship grants an order for the applicants, the effect would be a message to the MK party, to all the parties in the National Assembly, that you have to get your house in order. You cannot, the long story that I outlined earlier this morning of not knowing who your members are, not having proper governance, receiving taxpayer money and treating Parliament as a revolving door without any procedure, and the manner in which the MK party is being governed. As Mr. Zuma set out in his answering affidavit, cannot continue. He says that they're not going to follow any democratic principles until this Congress that will take place on an unspecified date. He cannot do this, and the reason why he cannot do this is the harm that the carnage that he's leaving behind of members of the MK party. He admits to having ended their membership of the party and in the National Assembly abruptly, without following any procedure. And the toll that will take on their families, they quit their jobs to become members of the National Assembly. And the court to say, no, slow down and stop. Get a democratic system in your party in place that protects the rights of not just the group of 10, not just the dependents, but all the people that have voted for the MK party, expecting that they would adhere to the principles of just administrative action, the dignity of the people involved, the children that are affected, all of them are no consequence at all to Mr. Zuma. So it's just, that is the message, if we're to grant the relief. If my ladyship is not persuaded and believes that, no, look, they'll go with the first responder, the MK party, then this court would be condoning what Mr. Zuma said he's doing to his own party. The court would be saying, right, look, this review application, you filed it. It's an unprecedented review. I accept that. I accept that for the reason. I think during the postponements, we had my ladyship ask me those questions on, on the review. It's a unprecedented review for several reasons. Because there's no political party has ever behaved in the National Assembly in the manner in which Mr. Zuma said his party is going to be run. It's just never happened. We've never been in this situation before, where members of the National Assembly are so poorly treated. So this court would be saying, well, this is the way that things now happen in South Africa.
Do you seek costs, Mr. Chitalo?
I do seek costs, my lady. The
On
costs,
scale?
the twin-inclined scale, my lady, and that's because of the manner in which the applicants have been treated. I do believe it does warrant a cost order. Mr. Zuma and the MK party could have, not just today when we're trying to settle, heard the arguments that I was making on my feet that, look, we can't do this. When I think it's common cause, it's not in the papers, but it is common cause that when former President Zuma was in the ANC, he got disciplinary hearings, but he won't give the members of his own parties an opportunity for disciplinary hearing. A court order, a cost order that takes that into account is, I believe, appropriate.
Anything further?
My ladyship, I don't have anything further.
Good, thank you. Thank you, Ms. Nyati.
As it pleases the court, my lady, I must first thank your ladyship for being so patient with us, both this morning and this afternoon. My lady, I would like to begin with the stage that we are at with this application, and that is really just based off of the applicant's heads of argument, where they do state that there's a return date. And I do want to clarify that, my lady. Let me begin with the draft order. I haven't seen it in the court bundle. If I may hand it up to your ladyship.
Thank you.
In terms of the draft order, my lady, it was agreed between the parties on the 21st of August. That was the day after the launching of the interdict, that the parties would file their papers on specific dates, as well as the filing of their heads of argument. What the order does not include is a return date for a final order to be given, my lady. So it is our submission that the events have been overtaken. There is no return date for the hearing. And for that reason, my lady, we are moving for the dismissal of the application. Perhaps it is also opportune to mention, my lady, that the applicants were given the opportunity for the 7-day period between the filing of their founding papers and answering affidavit to file their confirmatory affidavits. He has just mentioned that there are confirmatories. There are none on the papers, my lady. That is also with the date that was given to them to file their replying papers. That was last week, Friday. My lady, what I have in front of me at least is what is in the court bundle. I haven't received any confirmatory affidavits, and I also do not know what any other parties would have stated. And I believe your ladyship is in the same position as well. And also, as your ladyship correctly stated, there is no replying affidavit. So what that means is that we have an answering affidavit with allegations that are completely unanswered. My learned colleague has attempted to justify some of those in heads of argument, but for those submissions that are not in the papers, milady, cannot be accepted by the court because there are submissions from the bar. And some of those submissions include whether all of the applicants or some of the applicants are currently in Parliament and whether they have received any specific benefits. And that, milady, speaks to what has now been deemed, not deemed, but rather called an eviction, loss of benefits, family members who are purportedly being kicked out, whether it's today or tomorrow. What is on the papers, milady, by the first applicant, it has not been confirmed by the second to 10th applicants, is that the first applicant attempted to enter the parliamentary village and they were unable to. However, his legal representative intervened and he was allowed to enter. What it does not state, milady, is how long he's been living in parliamentary village and if he has been living there at all. And the same goes for the second to 10 applicants. There's also nothing to show, milady, why they are entitled to the benefits that they are claiming, and those are the grounds of urgency. The grounds for urgency are that they have been stopped, or let me not say they, milady, I'm going to specifically refer to the first applicant, because it is our submission that the second to 10th applicants, they have given no authority, they have placed nothing before the court to show that they are experiencing the same averments or conditions that the first applicant is claiming to. We'll begin with urgency, or rather I'll begin with urgency, milady. Of course, that determines whether we can even delve into the grounds for interdict. And we do say that it's not urgency. Milady, what we have before us are certain facts. And these are allegations that have been made out in the answering affidavit that have not been denied by any of the applicants, including the first applicant. On the 23rd of June, 5 letters terminating the membership of certain persons who were in MK were sent out. 2 of those letters were to the 6th and 9th respondents. That was the 23rd of June. Their membership was terminated. And a day afterwards, 12 others were also terminated. And the grounds for that, milady, are also set out in the answering affidavit as to why their membership was terminated. I've also set that out in heads of arguments that appears from paragraph 6. And I'll mention some of them. It was because the names that had been added to the candidate list were either improperly or irregularly included, and the submission of names was made without proper consultation and vetting. There was a mishandling of the party list by the person who was responsible for that, and that was the previously acting Secretary General. Upon realizing this, that there was a mishandling of the party list, milady, he was then replaced with Mr. Ngubane. And that is how they discovered with internal investigations that there were a number of persons who weren't supposed to have been on the party list to begin with. And the rest of those persons are the applicants to this application. Their membership was terminated on the 24th of June. How they came to be members of Parliament or sworn in, as they state in their founding affidavit, milady, is an anomaly because it means that they arrived there without the membership, the jurisdictional fact that allows them to be a member of Parliament to begin with did not exist. It did not exist at that stage.
They were on the list.
They were on the list, milady. However, by that time, their membership of the political party had been terminated. And on the list, it was for that reason as well that on the 5th of July, a supplemented list a supplemented list was delivered on the 5th of July to the National Assembly. Those are attached by the applicants, if I'm not mistaken. If I can just have 5 seconds for this one. It was attached in their review application. It appears from page 39 and I think to page 46. And in that list, that's dated the 5th of July, it includes all of the applicants, milady, as members of the MK. However, their membership was either terminated or they had resigned from them. And again, the reasons for that are set out in the answering affidavit. The reasons for that have not been denied by the applicants. Milady, what we have is, and if it is so that the 2nd and 10th respondents have indeed given authority for the launching of the application, we have applicants before your ladyship who are trying to retain benefits that they were not entitled to in the first place by the time that they were sworn in, because their membership had already been terminated. Milady, this application was launched on the 20th of August, yes, following correspondence from the Speaker. But the termination of their membership had occurred 2 months prior. So urgent was the application that they had sought for the first and second respondents to file a notice to oppose on the same date and an answering affidavit on the same date at 4 o'clock for the matter to be heard on the 21st. Milady, it is our submission that this is one instance of entirely self-created urgency. And the purported rights that they seek to protect do not exist in the first place. On the points in limine, milady, we have raised locus standi, non-joinder, and the jurisdiction of the court. And we begin with jurisdiction for one reason. The decisions that are challenged in the review application, which they say this part is pending on that, are with regards to the termination of their membership. The termination that occurred between the 23rd and 24th of June, 2 months ago, or 2 months prior to the launching of the application. And those decisions were made in KwaZulu-Natal. They were made in KZN, in Durban. Interestingly, my lady, the applicants also do not inform your ladyship when they left their jobs or the previous work that they had done, when they left their homes, which is presumably in KZN, seeing as their memberships were terminated before they were sworn in. Milady, that is our submission on the jurisdiction and the lack of jurisdiction for this court. With regards to the locus standi, that has to do with the bodies that had terminated the membership. Of course, that has also been set out in our heads of argument, and that also answers the non-joinder point. And to finalize on why we do not believe this matter is urgent, milady, is also to deal with the relationship between political parties and their members. Milady, we live in a country where, and your ladyship had correctly referred to Ramakatsa, and that it does set out what that means. It means that first, when you join a political organization, it's voluntary, and you're bound by its constitution, which they say there is no constitution, but a political party cannot be registered without constitution. They've attached a draft constitution. I'm not too sure why they haven't attached the actual constitution which they bound themselves to.
So there is a final constitution.
My lady, there's no political party that can be registered without a constitution. So that is in terms of statute. So there has to be a constitution.
So there is a final constitution.
And it has been stated in the answering affidavit that there's a constitution, which they have not challenged.
Why then, why this factual dispute about the Constitution? Can you explain why there's a factual dispute as to whether a Constitution exists or not?
Milady, I believe the dispute is with regards to the draft Constitution. So in the review papers, they had said that there is no Constitution, and for that reason they attached the draft Constitution. And of course, with the paragraph where they say they include the submissions in the review papers as part of this application, that is where we do state that a political party can't be registered without a constitution. There is a constitution. Whilst there is a draft constitution, that of course is agreed to between the members, and I cannot state where the process of that is, milady, because it's not on the papers. But there is a constitution.
So that constitution's just not placed before the court?
It's not in the papers, milady.
In fact, I can't find the draft constitution either.
Or the draft constitution.
So we simply don't have a constitution put up. Well, surely then just on that basis alone, the matter can't be dealt with.
Indeed so, milady. I was addressing your ladyship on the relationship between political parties and their members. Milady, for Section 47(3)(c) to come into effect, and that is for any persons to be a member of parliament, it is through the submission of a candidate list. That's expired, milady, by the 5th of July already, where the applicants had no rights to enjoy the benefits of being a member of parliament or being within the National Assembly, or to be able to go to the parliamentary village, or to have a stipend of over 100,000, or to enjoy the benefit of domestic flights. It never existed to begin with, is our submission, but that was made final when the supplemented list was sent. Milady, those are our submissions on why the application is not urgent.
So you then seek that it must be struck from the roll for lack of urgency?
We seek the dismissal of the application, milady.
Of the application.
Absolutely, milady. There's, to put it very lightly, there's just no case. We don't know what rights they're even relying on. Where are they taking it?
Do you have other submissions?
On urgency, no, milady. Those are our submissions on urgency. Milady, on the grounds for the interdict, we then have to deal with the actual relief that is being sought in the notice of motion. It's prohibitory relief against, perhaps we should go there. In the first prayer, of course, they are dealing with urgency. In prayer 2, milady, they are seeking to prohibit the submission of names of candidates to the National Assembly by MK. A party which they have not stated they are a member of, a party which we now know on the facts that have been placed before your ladyship they have no membership for, and they are attempting to stop them from submitting candidates lists to the National Assembly. That, of course, is a statutory power that is exercised by a political party. And in prayer 3, they are trying to prohibit the National Assembly from swearing in certain candidates. Milady, we now are dealing in the realm of outer, where the applicants are trying to prohibit or interdict the exercise of statutory powers. Absolutely no case has been made out on the papers as to why exceptional circumstances exist. And this is what has been stated in outer. You have to demonstrate that it is an exceptional case which justifies the interdict of the exercise of statutory powers. You also have to show that it is a clear case, milady, a strong case. Lady, they don't do that on any leg. They don't do that for Prayer 2, they don't do that for Prayer 3. And as a result, they also don't do that for Prayer 4, where they are trying to retain benefits which they have no entitlement to and which they never had any entitlement to begin with. No exceptional circumstances exist, my lady.
The return date issue is dealt with in 5, is it not?
My lady?
The return date issue.
It is, my lady. So this was the application that was, of course, that had been launched on the 20th. However, because the parties agreed to certain dates, it would have been included in the draft order itself.
The draft order.
Yes. So the draft order itself is what overtook the rule NISA that they have sought in their application. The prima facie case which they have relied on is a paragraph in the review application with almost a general reflection on probably all the rights in the Constitution, including trade and, sorry, my lady, if I may just go to it. It's paragraph 29, and it's page 29. They refer to the right to administrative action, procedural fairness, equal protection, dignity to be respected and protected, freedom of association, political rights. But it doesn't speak to the rights in the interdict that they are trying to protect.
Page 29 of the review application.
29 of the bundle. The review application is 14 pages long.
The review application, I was going to say, because it has nothing of something of no page 29. But it's incorporated by reference apparently into there's reference to it made. In the
reference to it, no quoting it, my lady. We do have certain rules when it comes to motion proceedings. You can't just make a bare allegation on your annexes. You have to refer to the parts that are relevant and which you're using in support of your case, my lady. Those are the principles that are applicable to motion proceedings. So perhaps I should withdraw my submission on the rights that they are trying to protect, because that has not been, in fact, stated in the application. My lady, they then have gone to apprehension of harm. That is also not entirely clear which harm they are trying to protect for rights which never existed. Also as persons whose memberships were terminated and who were not entitled to have been members of parliament in terms of section 47, subsection 3, sub C. They then say the correspondence from the legal advice of the National Assembly indicates this. My lady, these are facts that they have known about for 2 months. They knew about these facts at the date of preparing these papers. On alternative remedy and balance of convenience, and my learned colleague has used the word hamstrung. My lady, it puts National Assembly in a difficult situation where they have received candidate lists from a political party. It's a power that has been exercised in terms of Section 47, and for the National Assembly to receive that list in terms of Section 47. They are actually being hamstrung by the applicants who are seeking to be members of Parliament by virtue of a membership that doesn't exist. That is the hamstrung part. That is what is being hamstrung. And when we make a reference to the term, that is what we mean. Lady, there's absolutely nothing that they've stated on the papers on the balance of convenience, on the apprehension of harm, and the small paragraph that they referred to on the prima facie right. And my lady, to conclude, I think just about all of our submissions have been made out in our heads of argument. And I would like to refer your ladyship to those heads of argument. And I didn't want to regurgitate them, but to take you through those very important parts of what our case is. Milady, we are still seeking a punitive cost order. We have set that out in our answering affidavit. And that's for several reasons. We were brought to court on a day's notice to file answering papers on that same date, on facts that were not fully placed before the court. Thankfully, because we were given provision to file answering papers, we were able to put those facts before your ladyship. And those facts are not denied by the respondents. So it must mean that they knew about them to begin with. They knew that their memberships had been terminated 2 months earlier. Milady, they have not delved into the separation of powers harm. That was the outer test, albeit seeking the relief that they are seeking. So at that stage, when they set out the relief in their notice of motion, they should have known that they need to set out the exceptional circumstances to justify the orders that they were seeking. They should have known at the preparation of their heads of argument or even a replying affidavit, which they elected not to do, that they would need to address your ladyship on that, and they still have not done so. It's unclear on what basis they are seeking this relief. Even if your ladyship were to find that it is urgent, no other basis has been set out for the interdict. And for those reasons, my lady, we do submit that a punitive cost order should be granted against them, and that is our case. If your ladyship does not have any further questions for me.
Thank you, Ms. Nyati.
As it pleases the court.
Thank you, Mr. Chitando. In reply?
My lady, before I reply, may I quickly take an instruction
Yes,
from my
certainly.
attorneys into receiving messages? Thank you, my lady. I'll start where my learned friend began. On the issue of the return date, the notice of motion, my lady, I refer you to page
Does
2.
in paragraph 5 refer to return date,
Yeah,
the
the
1st of October.
1st of October. So that's, I think that deals with that point. So there is a return date. In regards to the confirmatory affidavits, those were filed this morning.
Were they served
Yes, they were.
on Mr. Tulu?
I believe they were, yes. That's what I was in.
But the way this has been litigated is, in the morning of the hearing, you file confirmatory affidavits.
Yes,
It's confirmatories in respect of a founding affidavit filed some time ago, and in respect of which there already an answering affidavit filed. There's no replying affidavit filed.
There's no replying affidavit, but there is, and the reasons for that reply, the reason why there's no replying affidavit has been given to your office already, and the.
But there's no
respondents.
reason why these confirmatory affidavits were not filed timelessly. Nothing's advanced.
The reasons for that, I understand, my lady, that the challenges that the applicants have, but the most important thing is there are confirmatory affidavits.
But this
They
is
were
not how
filed.
litigation works, Mr. Chitando, as you well know. You
I'm
have a founding affidavit filed, then then have an answering affidavit on your demand filed at very short notice, and then to file confirmatories ex post facto places the court in an invidious position where the litigation is just ad hoc and chaotic.
It is
What the effect of it is that the respondent has not had the opportunity to deal with any of the issues raised in the confirmatories.
My lady, what I would like to go, we're talking about confirmatory affidavits as though they're quite long. What the confirmatory affidavits do, which were filed, they confirm that they agree with whatever is said by the first applicant. That doesn't prejudice the respondents at all. It just says that Mr. Kuzwayo speaks for us. That's what they say. They don't make up a new case. No new case was made by these confirmatories at all. All they have done is to confirm that Mr. Kuzwayo spoke for them.
But then none of the personal factors of any of the applicants are before the court.
the confirmatories do mention the people who are affected. And my lady, the position that I'm in, I understand what my ladyship has said, the position that the court is in. But the position I am in is that I'm getting the applicants, they were put in the situation by the respondents where I think 80% or 90% of their pay was cut abruptly. They're all in dire straits.
Chitando does not explain why why litigation occurs in this manner.
I believe, my lady, when you're in that situation, realities, commercial realities, and realities of living, these are not people that are in a great situation. They've been badly affected.
They are represented both by counsel and an attorney, and there's no application to this court to condone the manner in which the litigation is proceeded. To file confirmatory affidavits on the day of the hearing, which has been long arranged, is simply not according with accepted and known legal practice as to how urgent applications are run.
My lady, urgent applications are a creature of its own. It wasn't a long time. I was last week. So we're talking about a space of days.
But it's not for
Not
the
months.
applicants to just file whenever they chooses and when it suits. The court needs to be placed in a position where it's able to consider all aspects of an application and have the relevant documents before it. And the respondent, too, needs to be able to be in a position to answer to anything that comes up. And that's the difficulty with the litigation taking place in this manner.
My lady, the litigation, the way that this litigation has been taken, and it speaks directly to the urgency of the situation. The applicants are doing what a party who has been affected, the way that they have been affected. No one besides them have been as poorly treated and as badly affected
Mr.
by the
Chair,
circumstances.
I would have expected that the response to the court would be, we accept that, and for that we express regret, and we would ask that the court condone any non-compliance and any late filing of documents on the date of the hearing. That would be the response one usually would hear from counsel, to say that is why these affidavits are filed so late. This is why it's taken place in this manner.
My lady, but that's what I'm doing. I'm talking about the circumstances. I cannot just say what condone for the sake. I'm saying that we look at the facts before this court, and they speak to why they're in this way, why they had to. In fact,
right. So
I think the correspondence was sent on, was it yesterday? Email correspondence where they talked about how they've been threatened. Many of them are afraid to come into court themselves physically. They're afraid to meet. They've received. They said that we received threats. They don't want to litigate on the basis of the threats that they have said. But the correspondence went out yesterday, my lady. The circumstances were set. It was an email. I saw it that was sent not just to the court, but also to the respondents. The confirmatory affidavits do not make out a new case. What I'm doing now is arguing why they're in the situation that they're in and why it should be committed.
All right, I've heard you on that. That the confirmatories don't make out a new case.
They
There
don't.
were personal circumstances which made it difficult to file those confirmatories timelessly, and that accounts for the delay in filing them.
My lady,
That you take issue with what Ms. Nyati stated, that the respondent has not received the affidavits. You say that they were filed and served and filed this morning.
Buddy, I'm going to go into.
There's no proof, incidentally, in the court file that they have been served and filed. So that
My lady, I've just received instruction. The confirmatory affidavit was served yesterday by email. I'm filed this morning. And the confirmatory affidavits, they don't just when it comes to the dependents. My lady, the confirmatories don't raise the dependents for the first time. The fact that they're dependents. The founding affidavit does. And the respondent's answering affidavit responds to that. So there's no new case that's been made up by the confirmatory affidavit. It's a technicality to say, right, look, for the sake of technicality, we say that Mr. Kuzwayo speaks for us. And Mr. Kuzwayo said that our family members have been affected. That's not a new argument, my lady. It would be prejudicial to the applicants to say that, look, you have litigated this thing badly. Mr. Kuzwayo was the person they went to and said, "You go and speak for us." And he did. He talked about the personal circumstances. He spoke, I think it's important I refer you to the paragraph where that is set out. I think it's paragraph 84 and 85 of the founding affidavit. No, 34 and 35. Page 30 of the bundle. The applicants were gainfully employed before they joined the National Assembly. They resigned from their jobs after they accepted the MK Party's nomination to the National Assembly. The respondents' administrative decisions have left all the applicants unemployed without any due process, in a manner that is inconsistent with our constitutional rights. Paragraph 35. The applicants are breadwinners and have dependents who include minor children left without financial support as a direct result of the respondents' administrative decisions. It follows that the respondents' decisions are not in the best interest of the affected children as provided for by Section 28 of the Constitution. My lady, you could not get more specific than that. That was not a case that was made out this morning. That was a case that was made out as we're speaking about detail on the 19th of August 2024. It's not new. It was not made out this morning.
But there weren't. The point is that there were not confirmatory affidavits.
There were no confirmatory
at that time, and therefore the respondent was within its rights to then respond to answer to that allegation by saying what it did in its answering affidavit with regards to paragraph 34, in its response to paragraph 34 of the founding affidavit, and that is that I deny that the facts deposed to fall within the personal knowledge of the deponent and are true and correct, nor is he competent to make the legal submissions made. She ought to be rejected on that basis because there were no confirmatories.
My lady, that is a bare denial, first. And that answer does not dispute the fact that there are dependents. It's to deny that adults have children and they put you to the proof.
But there are no specific details. This affidavit is so thin on fact. That's the difficulty.
We have an urgent application.
But urgent applications need work as well. You can't just file an urgent application of 11 pages without sufficient fact. For instance, you plead expressly that there's no constitution of the MK Party, and the answers in the answering affidavit states the contrary. There's no constitution placed before this court. The court's asked to determine an urgent application in respect of a matter which turns fundamentally on a constitution of a political party, and the constitution is not before the court.
My lady, I'm going to get into that point. I would like to go deal with one point at a time, and I think we're dealing with the confirmatory affidavits, not the constitution. I'll get to that. I want to go through the reply in the manner in which the respondent's counsel has set out their answer.
Proceed.
Right, but the confirmatory affidavit, my lady, that point, unfortunately, we're in a situation where the realities are, the facts are, that at paragraph 34 and 35, submissions were made and they are crystal clear to me. I've read them out. They say that the applicants are breadwinners. They quit their jobs to join National Assembly. They did that. And that was before the court on the 19th. This is an urgent application. We spoke of, and we have to look at everything in conjunction. We cannot look at the application in isolation. We know that the letter from the Speaker, I think that was the 19th of August as well. On the same day, they're communicating with the Speaker, saying that tomorrow, on the 20th of August, there will be no swearing in after the communication that took place. So this is the nature. This is what's going on. We've got one of the applicants that has come and he's speaking for everyone, and he has made out these submissions. Those are facts before this court. They're facts that we cannot close our eyes to. The confirmatory affidavits do not make out a different case from what the founding affidavit did. It doesn't. Now, my lady, what the detail that the confirmatory affidavit does go into, which is not in 34 and 35. My ladyship, you said that everything must be there. It's urgent, but still do everything. Okay. I'll deal with that point.
Well, the important
But,
material
here-
facts need to be there
just-
in order to allow the other side, Mr. Chitando, if you were for the other side, in order to allow you a full and proper opportunity to answer.
Yeah, but I would not answer in that manner, and I'll tell you why, my lady. They've said that they've got dependents. What do the confirmatory affidavits do? They list the number of dependents. One says 3 kids, the other says 2, other says grandparents. But the most important thing is that they mention dependents that rely on them. That's the point that they've made to this court. And my lady, if I may land the plane.
But Mr. Chitando, the point that's made by your opponent is that there hasn't been an opportunity to answer to these allegations.
Okay, then, my lady, I want to deal with
the confirmatories are put up after the answering affidavit, and they contain facts to which, in respect of which, the respondent has not had an opportunity to answer. As a basic, as a common practice, it wouldn't be permissible unless it was an ex parte application.
My lady, I want to say why I disagree with that. The confirmatory affidavits go, and I was saying this before my ladyship made this point. I'd like to make this point crystal clear, so we're all on the same page. The founding says that we've got dependents. The answer says you have not given us the exact number, or you haven't given us enough detail. It doesn't say the number. What the confirmatory affidavits do is they give the exact number. But my ladyship, my point is to this court, does it matter how many numbers? The point of the matter is the principle that their dependents, who include minor children, who are going to be left out. That is the point, my lady, that I'm trying to make. The fundamental point is,
I don't think there's any difference of opinion on that, Mr. Chitando. That you plead that they're dependents, and it may not matter. It may, in fact, have limited application to the matter. The point is just the practical point that the confirmatories contained information that wasn't put up prior to the filing of the answering affidavit.
Okay,
that's really the issue. And it may not be as big an issue as... it may not require the time that it's now taking to discuss it. The court can deal with it in its judgment, and it can deal with the timing of the filing of the replying affidavits.
But my ladyship mentioned how this affects, in your address to me. You were saying that...
making an address.
Sorry, I apologize. I meant to say the respondent's address and your question on the respondent's, to me, the questions that on that issue. The confirmatory affidavit is you say that the manner in which the matter has been litigated. As I said before, it doesn't change, it doesn't prejudice the respondents. It just says Mr. Kuswa speaks for us. And when he said that we've got dependents, he didn't say I have dependents. He said we have. That's what paragraph 34, 35 says. We have dependents. That was before the court on the 19th. Sorry, that was deposed on the 19th, and it was in urgent court when the matter was before Judge Erasmus. There's no new case.
All right, thank you. I'll take a note of your point. Could we move then to the constitution point?
My lady, if I may, I'll end up getting all jumbled up because I'm responding to the respondent's case, what she has set out, and I want to go in point form through what she has put out. So I've mentioned the confirmatory doesn't change anything. The suffering of the respondents say that the suffering that the applicants have endured is not set out in the founding affidavit. That's what she said in her address. I've already said that paragraph 34 and 35 does set out the suffering that they've endured. Quite clearly, I cannot think of anything more difficult for a parent than to receive a minister's decision saying you're no longer part of a party, you're no longer in the National Assembly, and in days you need to leave. That's what they're saying there. What they're saying on paragraph 34 is quite clear. It's crystal on what the applicants have gone through. My lady, in regards to the manner in which the decisions are subject of review were made. A review application in terms of Rule 53.4 would then give the respondents an opportunity to oppose, which they have not yet done, and then set out the reasons for the decision that was made. The answering affidavit does provide some reasons, but the answering affidavit is inconsistent with itself. And that I've already gone through this morning of what Mr. Zuma is saying happened and what actually happened. He contradicts himself. He says they're members, but at the same time he says they were not members. Once the reasons are before the applicants, they can supplement their case. If Mr. Zuma keeps changing his case, they can supplement the founding affidavit in terms of Rule 53.4. They can amend as well, and then the nature of the review can change depending on what's in the record. Because what we have is a situation where the respondents are saying they were never members to begin with, but if they're members, I expelled them. They fortunately got onto the lists, and all of that, there's the disciplinary processes and procedures, that'll all be in the reasons. And then the applicants will be in a position to follow the rules of court and change their papers if the story of the respondents changes. In regards to the Constitution, my lady, the respondents do not refer to the Constitution, following the Constitution in the manner in which they expelled them. They don't refer to that. There's obvious confusion of what's going on in the MK party. They say there's the ILC, I believe, and not the Constitution gives Mr. Zuma the power. That's the evidence before this court. And the papers that the applicants and the respondents have put forward may not include the Constitution, but what's clearly taking place here is that there's confusion as to what constitutes the MK party. This is an unprecedented case, my lady. No one, Mr. Zuma is saying that no one besides him has the power to deploy or to remove anybody, with or without a constitution, draft constitution, existing constitution that was used just for the sake of getting this party registered with the IEC. The respondent's case, and we go to Plascon Evans, the respondent's case is that they didn't follow the Constitution. They say that Mr. Zuma didn't have to follow the Constitution. So whatever draft or, this is a chaotic situation that's been created by the MK party itself. But whatever governs the MK party on the respondent's version is not a constitution. It's an ILC. That's in the founding the answering affidavit. There is no constitution referred to by the respondents in their for justifying the expulsions in their evidence. And my lady, that's the version of the respondents, and we have to follow that version. Again, I think, my lady, if whatever document that the respondents come and say that this is the actual constitution, that can come out in terms of the record in the review. But where does that leave the interdict, my lady? I want to go back, if I may, to my heads. To be page 8 of my heads of argument. And I apologize if I sound repetitive, but I just want to go back to the test. So I can satisfy this court that the applicants have met their test, irrespective of what argument the respondent's counsel has put forward. In an application
But I
for...
think it
I just want to, I'm not...
So if there's a point that you want to raise, that Ms. Nyati raised, that you want to respond to, that's the purpose of the response.
It is in response to that.
All right.
I'm responding with the test.
Well, you please don't restate it.
All right, I won't
Knowledge
restate the
now.
test.
Yes.
But my learned friend did say that, and I think even the answering affidavit says that there's a long laundry list. The word was used as laundry list, or two words were used, laundry list of constitutional rights. And we don't know what rights they're relying on. The prima facie case that has been put forward in the heads of argument is just administrative action and the lawfulness of that administrative action. That is what has brought the applicants to court.
That's the right you rely on.
But that's what it's a review, my lady. The applicants are reviewing and setting aside. And my lady, Section 6.1 of Parliament, if we're to, this is something for the review application down the road. But Section 6.1 of Parliament does give any party the right to come to court and say that the lawfulness of the decision, we're questioning that. And it is very clear what the applicants have come for. They've come to set aside administrative action. The administrative action that Mr. Zuma has admitted to making. He has said that I have got the sole power, not the Constitution, the power to do what I like. Not the first phase, and I assume the first phase is this Constitution. I mean, that first phase, it's so confusing. But the first phase, he says that
without the Constitution, one wouldn't know what power that Mr. Zuma, in fact, would have. It's not before the court. I can't determine that issue.
But what the court does, what is before the court, is the fact that he is saying that he has got sole discretion.
But I don't know that because I don't know from the Constitution. Maybe the Constitution provides something like that. What must the court do when it's when it's faced with an application, an urgent application, which might be entirely meritorious, but in respect of which the fundamental documents required to determine the matter simply not placed timelessly before the court or at all?
My lady, we are at the interim interdict stage.
That's correct. Even at an interim interdict stage, Mr.
Yes,
Chitando.
but
the court can't willy-nilly grant court orders,
and we're
even
not
if they're
asking
of
the
an
court.
interim nature.
But we're not asking that. What we are saying is that, my lady, with the facts that are before this court, given the admissions that Mr. Zuma has made on how he's governing the party, and the people that are affected by his decisions, and when the review application runs the way that it's supposed to run in terms of the rules, could a court find? Right. There is doubt. I think Beecham does say that there could be, it's subject to doubt. I'm not trying to say that there's no doubt. That's at the interim interdict stage. That's not the burden that the applicants have to follow, have to meet. But with the admissions on how Mr. Zuma says he's governing the MK party, can the applicants succeed in setting aside those decisions? And the answer is yes, they could. When the review runs its course, my lady. And that is the argument that the applicants have made as prima facie rights. That is their case. The purpose of today's hearing is not to argue the entire review today, but to say, can they, with what Mr. Zuma has said about how he's conducting his party, and what the applicants have said about how they've been affected by the governance of his party, can we set aside the decisions that he's made? And the answer is, my lady, and I submit, yes, exceptional circumstances outer, and then I think I'll be concluded. Exceptional circumstances. My learned friend says that they're not there, and I say that they are. And the reasons why I say that they are is in the founding affidavit. I've already spoken, and I won't repeat. We're almost all done here. I already mentioned the dependents. That's at 34 and 35. So I won't burden the court with a repetition of the fact that these are applicants who are breadwinners and have been negatively affected by Mrs. Zuma's decisions. The exceptional circumstance, which is objective evidence, again, I won't repeat the letter from the Speaker. Where she is saying that I'm going to replace you. You've been terminated. Your positions have been terminated. However, they were terminated. It's got nothing to do with me, but I'll replace you, and then you will be left in that situation, replaced, without an interdict. And the review is then moot, and they've got no recourse whatsoever. They're then stuck in that situation of being roughly and rudely treated in the manner that they have. And whatever relief that they get in the review is pointless. In fact, at the review application, what will probably happen is the respondents would say that this matter is moot, the horse is bolted. We're now doing it's not an academic exercise of how Parliament should be regulated in the future. It have no practical force or effect, whatever judgment takes place at the review. That is an exceptional circumstance, given the positions that we're talking about, the seats in the National Assembly. There cannot be anything more exceptional than that. That's the reason why this matter has got the attention of the public. That is exceptional. The millions of people that voted for the MK party put their confidence, and Mr. Zuma says in his affidavit that millions of South Africans put their confidence in him, and then he has done this to the people that helped him get 53 seats in Parliament. And now we're talking about 10 of those 53. That is an exceptional circumstance. It's set out there in the paper. So, my lady, in response, there is exceptional circumstance. It's there by the nature of this application. My lady, that is, I think those are the points that, there's a note here. I'll just take one more instruction if there's another point. That is the case for the...
Do you have a draft order that you're seeking? Or are you seeking relief in terms of the notice of motion?
In terms of the notice of motion.
One to 1.1 to 7, I see. 1 to 7 of the notice of motion. Where's 1 to 7 of the notice of motion?
That's correct.
Good. Thank you. I'm indebted to both counsel, heads of argument and argument today. Judgment is reserved and you'll be informed as soon as it's available.
As a court pleases.
As a court adjourned.
Now? Right. I will not.